Welcome back to In Sync with Synchronomics. I'm James Holland with my co-host Jamie Linkowski.
Hello, everybody.
And we're back in the podcast continuing our discussion around the shifts that are taking place in the employee benefit world, the different changes for retirement plans and healthcare plans, and how they're being administered. Last time we talked, we covered a recent court case, a Supreme Court case of Cunningham versus Cornell, where the Supreme Court sided with the retirement plan participants who had sued Cornell University for excessive fees in their 403B plan. It marked a significant win for the university employees, and if you haven't listened, definitely go back and get the details. But we also got into discussion on how those decisions are also changing the game for healthcare plans as well. That's why today we really wanted to start to kick the dirt on healthcare, and more specifically, we wanted to talk about the fact that employers have to get more serious about auditing their plans. So, Jamie, the first part we want to look at is why is it so hard? Why are employers having such a hard time wrapping their hands around healthcare plans and how they should be administering them, and why is it so important?
Well, the hard part is actually easy to explain in that traditionally employers have not had complete unbridled access to their data. And prior to the Consolidated Appropriations Act and some of the transparency laws, they would ask and summarily get told, no, read your contract. And if they got any information, it was restricted to the amount of information, the number of data files, what they could do with the files, and they couldn't use it against their carriers. That has now changed, but employers work in the habit of not realizing that it is their data and they own that. Now, to the question of why it's so important to put in the effort to get your data, it's like everything else from a procurement standpoint. You know, there are many employers who probably spend more time understanding how much they pay for Post-it notes and paper clips than you do healthcare. And there's no way you can, fix something if you can't measure it. And you're certainly not going to save your money or your employees' money if you don't have unbridled access to your data.
Jamie, that was a great introduction. The first deep dive into how we can improve the audits is going to be the conflicts of interest. Obviously, who's getting paid, how much, by who, how do the employers control that, or even find them to begin with, and then go about controlling those to make sure that they are still putting the participants first?
Right. So as we probably discussed at some point, at its simplest, a conflict of interest happens when the party involved in your plan, whether it's a consultant, a broker, the TPA, or the PBM, pharmacy benefit manager, has competing incentives than the employer or the employees, and they're not aligned with the fiduciary duty to all of the participants. We've seen this time and time again, whether it's the Anthem Blue Cross ERISA case that sponsors allege that Anthem failed to disclose compensation arrangement and allowed excessive administrative fees. We've seen, again, the M&T in 2019, M&T Bank, where revenue sharing between the plan advisors and investment providers was at the center of the dispute. Now, you take away those things, and those relationships also exist when it applies to healthcare, where brokers or consultants are paid bonuses or override commissions based on the carrier they place business with. When PBMs earn spread pricing or rebates, rebate revenue that's not passed through, or when a TPA recommends a stop loss carrier that happens to be their affiliate. Those are all conflicts of interest and need to be rectified.
You mentioned the one case. I don't believe there's been too many on the healthcare side yet that have hit the conflict side. But from a pure employer sponsor perspective, I mean, you brought up the PBM and the rebate aspect. You brought up the advisor who's getting paid that sometimes retention bonuses from the carriers. Is there a pecking order in how the employer should look at these? Is anyone more important than the other, or are we just trying to pick them off one at a time?
I think the lowest hanging fruit would probably be the pharmacy benefit managers with some of the specific healthcare lawsuits that are going on with the Johnson & Johnson. There's obviously Wells Fargo, and I believe there was JP Morgan Chase, if I remember correctly. Those might be some of the earliest, not to mention the Tierra Yacht lawsuit that was recently dropped.
Gotcha.
So they're definitely out there, and they're the plaintiff attorneys are definitely circling.
So to remove that target from the back, how does the employer spot that conflict of interest? And is there something within the plan that they could see that would trigger them saying, "Oh, look, now I have one"?
Yeah, I think we spent a lot of time maybe talking about the burden of the new legislation, but I think we've also mentioned in the past on a podcast where the new legislation actually, for the first time in history, has given the employer the tools to ask for this information. So it is incumbent upon them to basically audit every single one of their vendors. They are all covered service providers, whether it's the PBM, the broker, the TPA, the carrier, your dental insurance, your stop loss carrier, your data aggregator. They're covered service providers of the plan. Just like anything else you would do in procurement, you should audit that relationship. In fact, the CAA now mandates that you should have a fee disclosure of any direct or indirect compensation from those vendors in excess of $1,000. So yeah, it would be a simple procurement process.
Gotcha. So you mentioned we just about to ask about legislation. So the CAA that came out when again? Refresh my memory.
I think it was 2021, but it's ongoing.
Okay,
Right.
and so,
Somewhere there. Yeah.
again, so it's not like it just popped up. Again, it's been around for a few years, so employers should make sure they have a good grasp and understanding of the different moving parts within the CAA.
Yes. Yes.
Great. Is there one conflict that you see more prevalent in healthcare plans than others? What is there one that constantly pops up that should be again easily recognizable for employers?
I think again, the low hanging fruit is probably within the traditional pharmacy benefit managers. That industry has gone through a bunch of consolidation. So the marketplace is owned by, I think it's 80 to 90% of the marketplace is owned by three traditional pharmacy benefit managers: CVS, Express Scripts, and Optum. And anytime there's rebates, that's excessive, what would be excessive revenue sharing. Sound familiar, James?
Yep.
From our retirement days, you should probably understand how much that is, where it's going, and try and follow the money. And that places a big opportunity for the conflicts to actually materialize in monetary damages.
We hear time and again, obviously there's a sole and exclusive rule within ERISA for whether it be the healthcare or the retirement plan to make sure the participant is always put first. People are saying, well, if they disclose the conflict, then there's a way of justifying it. Are conflicts of interest always a problem, or is there some type of scenario where they can exist without it being an issue for the employer?
I think that you're better answering that question than I am, but I would say you definitely should understand the conflicts. They should be completely disclosed, but it's not a place where anybody should bury their head in the sand, especially in an industry like healthcare that has just been so opaque.
Yeah.
Where you have no level of transparency here to date.
Conflicts of interest in healthcare plans have again could be a huge issue for the employer, not just from an expense perspective. You talked about the PBM and some of the excess costs that are in there. Lack of transparency when it comes to pricing for different procedures and surgeries. And again, as a fiduciary, your job is to solely and exclusively take care of the participants. So if you cannot identify these things, again, you need an independent assessment done to show you that, in fact, you are following all the rules and regulations. So therefore, you can avoid having any issues or becoming a target of the increased litigation for which we see.
Yeah, I think particularly here, even more so than retirement, when you do the right thing from an ERISA compliance fiduciary standpoint, the employer will save money, the employees will save money, and from what we've seen, there will be better outcomes for the employees as well.
Yeah, well, great point. We talked a little bit about it in the last episode about the stress and things along those lines. We'll talk about financial wellness, but if you're worried about, am I going to pay the rent or go to the doctor, then obviously you're going to have a big issue, not just from a productivity standpoint, just a quality of life standpoint in and of itself. which is
Yeah, I think you can fix what we have called in the past the functionally uninsured. They have a plan, but they will not go to the doctor. So when you bring prices down, you make it more affordable to go to the doctor. They can be preventative. They won't skip appointments, and they'll actually be healthier in the end.
great. So now we're going to reset for a second and dive into that. If you find that conflict of interest, then what do you do to help cure it?
I think it really starts with the contracts, so you own the risk. You should know the laws. You should read your contracts, have them reviewed independently uh, by contract specialists, subject matter experts. Don't blindly trust your carriers or your brokers or those that just give you the contract to sign, but you need to cure. The CAA even says this explicitly with the gag clause, or not attestation, but the gag clauses, which is you've removed them right from your contracts. So that is something that you actively need to do and should have reviewed by an independent advisor, subject matter expert, and not necessarily take for granted or trust that the carrier who's giving you the contract has done that. So trust but verify.
Yeah, exactly. And you're about to hear a phrase now that you're going to hear on many podcasts. It's one of Jamie's favorites. So what? Now what? Okay, Jamie, we found the conflict. We're starting to put the pieces together. What are the steps that the employer needs to go as far as plan design change? Who do they talk to? Who's going to help put the pieces together, fix it, but then put the pieces together so going forward we can avoid these issues.
This is what I call getting comfortable with being uncomfortable, which is unbundling everything, unbundling all of your vendors. This would be a strict procurement process, by the way. Unbundle all of your vendors. Understand, look at the contract language, remove all the gag clauses, read those contracts, obviously, understand the clauses, hire independent folks, subject matter experts to review those things and fix and cure those clauses, and then price those vendors separately in the marketplace, and then see if you could put them together in a very streamlined, efficient fashion, which is, procurement 101. It happens to be also a fiduciary best practice.
Yeah, that was one of the things we saw. I didn't mean to cut you off there, one of the things we saw in the 401k space was everyone, do the bundle, everything's all together. It's easier. But then the problem is you get that almost circular firing squad where everyone's pointing the finger at each other and no one's taking responsibility. When you take the pieces apart and then you have some accountability, when you're putting the puzzle back together, then this part is responsible for here. The hospital piece is over here. The PBM piece is over here. The stop loss is over there. It's much easier to control when you look at it again. Just I get the old cliche of how do you eat an elephant, right? One bite at a time. Well, here we want to look at it one piece at a time. So therefore, we can put the best plan together for the employer.
Yeah.
Is there any? I know we talked a little bit about say you're reading the contracts. Are there any simple red flags that people can see that would obviously help pull at that string to get them going down the right path for correction?
Yeah, there are some simple catchphrases for gag clauses, things like you're limited in the number of claims you can see. They will tell you which claims you can review. That you can't do anything with that information once you get it. Those are simple red flags. They're gag clauses. And again, I probably should say something to the effect that you don't have to wait until renewal dates. You don't have to wait a full year being subject to as a plan sponsor. If you realize something is wrong, I believe it's your duty and it's imperative to start working towards fixing it immediately and not just waiting one more year of overpaying, knowing that you're paying the waste, fraud, and abuse that is inherent in the system. But, get to it as soon as you can.
Yeah, which is a great point. Yeah, because again, failing, especially for fiduciaries, I'm not sure a lot of people realize though, but if you've been informed of something that it could be a fiduciary breach and you don't act upon it, and you've been given the information to correct it, that could lead to another fiduciary breach. So again, people say, "Oh, we have a contract. I have to wait for renewal." may be the case, but at least to start the investigation, make a contemporaneous note that said, hey, I spoke to so-and-so on this day. We brought this to their attention. So therefore you have the documentation that you're trying to make the correction and put that prudent process in place, because there might be some things you have to wait to fix, but there are some things obviously that you can address right away, which obviously will also show that you're putting forth your best effort to put those participants first, like we talked about.
Document, document, document.
Yes, exactly. As far as the issues in the past, so the 401k plans, we've talked about it before. As far as one of the biggest things is you need to return the participant back to the position they would have been in had the breach never had occurred. What rights or what opportunities do the employers have to maybe claw back some of that money that may have been part of the conflicts or causing some of the breaches? Is there any?
Yeah, this is where I believe, we're going to start talking. James, you and I have talked offline here that we're really going to start looking at auditing health plans the way an auditor would or a fraud examiner would, where this is your largest unaudited expense. We are learning that auditors have not, there's been a blind spot, and they have not viewed this spend category like they have done other things in the internal audit. And again, I'll just reiterate, this is one of the easiest win-wins for both the employer and the employee when you do audit and you do apply the strict audit process as well as procurement process. EBITDA improves, you recapture, you have the ability to go backwards. There are some firms we work with that will go and audit some of those claims for waste, fraud, and abuse and recapture some of those overpayments. The amount of money that's coming out of the employer plan should probably be very close to the amount of money that gets to a provider. And when there's a big tracking error, that's a problem. They're not necessarily equal in all cases. And so you should understand what that tracking error is, what that differential or delta is, and there are ways to go recapture some of those overpayments.
Great, that's terrific, and that's that'll lead. We're gonna have a few final thoughts in terms of where we're all headed. The independent assessment is the key. So you have a fiduciary responsibility. It's the highest law known to man. So you really need to embrace that as an employer, even if you don't believe you are one. If you're involved in the process in any way, it's not a way just to protect yourself, but it's also a way to protect the employees. We're going to continue these conversations. So join us next month as we break down some more changes taking place within the healthcare and retirement plan space, why the industry is due for some continued disruption. And and as we're finishing this conversation, Jamie, I have a few folks who I believe might even make for a good guest in terms of, especially when you talked about that claims auditing process there. That might be the best place to start, because again,
I agree.
I don't think people realize that. I mean, in some cases, you're talking tens and hundreds of millions of dollars being spent here. And
No doubt.
if you can't account for it, then, that's where you're going to have a big issue. So in the
No
meantime,
doubt.
if you need help, or if you're wondering how we can help, please visit synchronomics.com. And thank you again for joining us for another episode.